Welcome. Thank you for joining us this evening to celebrate the official launch of Gehl v. Canada by Dr. Lynn Gehl. My name is Elsa Johnston, and I'm the Interim Director of the University of Regina Press. We'll start the event shortly, but before we do, I would like to acknowledge the land that we work on at the University of Regina Press and the importance of our treaty relationship to our existence here. My children are growing up in Regina knowing that we live, work, and play on Treaty 4 territory, the traditional lands of the Cree, Saulteaux, Dakota, Lakota, and Nakota nations, and the homeland of the Métis people. University of Regina Press has been so fortunate to have the opportunity to continue to work with Lynn and helping her voice to be heard. Her first book with us, Claiming Anishinaabe, was a huge success. And I know our senior acquisitions editor, Karen Clark, was pleased to be able to work with Lynn again on her second book, Gehl v. Canada. Now, before we dive into the main part of today's program, I have a bit of housekeeping to address with you. This event is being recorded and streamed directly to YouTube. And now tonight, we're happy to welcome Pei Ju Wang as this evening's guest moderator. Pei Ju is a settler living and working on unceded and unsurrendered Algonquin territory. She's an alumnus of Octopus Books, who are selling the books here tonight. And currently, she is the education coordinator at the City for All Women initiative. To start us off this evening, Lynn will give a presentation about her book, The Topic of Sex Discrimination in the Indian Act, and her 30-year court case. Following this, Pei Ju will lead a brief Q&A session, at which point Lynn will read from Gehl v. Canada. Pei Ju will then take audience questions from the YouTube chat. Now, throughout the evening, we welcome you to participate in the discussion in the chat. However, please be mindful that we strive to facilitate the safest possible space for our authors and guests. Please show kindness and respect to everyone in attendance. And finally, a reminder that you can purchase your copy of Gehl v. Canada by visiting octopusbooks.com, and a link to the book will also be provided in the chat. Now, without further ado, I am pleased to turn the floor and the mic over to Lynn.
Hi, yo kwekwe, makanak dodem, kitchisipin dunjaba, nagojawan megwan dida, gisike te manado kwan disnakas, and da shagana she knows when Lynn Gehl, and Donis and Don, she miss and Don, she goes and da, and we jigi kun and da, and we jigi wagon and da, up to go and do, chinan dam, and Anishinaabe kwe wayan. Thank you so much. I'm really happy to be here, and I think I'm just going to jump right in with my PowerPoint presentation, if everyone is okay with that. Okay, there we go. Can everybody see that? Can somebody give me the okay signal? Oh, nobody wants to. Okay, so can somebody give me the okay signal that my screen share is up, please? Okay, I'm good to go. I got the okay through the chat message. Marvelous. So of course I want to start by thanking Octopus Books, the University of Regina Press, ZG Stories, and of course Pei Ju. And there's some people behind the scenes, such as my partner Nick, and there's Elsa and Ryan and Greg. So thank you. And Nicole. So I would like to begin by acknowledging the land that Octopus Books is located in, of course, my home territory. I am an Algonquin from the Ottawa River Valley. This is a map that comes from Day and Trigger, and they rely on Champlain's records. This shows the Anishinaabe people who were in the Ottawa River Valley at the time of contact. So we have the Whiskerini up here, and we have the Matawiskerini, we have the Kississippirini, and we have the Golden Lake Reserve, now called Pikwakanagan, which is where my grandmother is from. So I'm going to begin by talking about Indigenous knowledge, because in all I do, I always try to bring Indigenous knowledge to the table, to the feasting table. Indigenous knowledge is different in that it values subjective knowledge. It also values emotional knowledge, reasoned knowledge, practice knowledge, and moral knowledge. So we bring different ways of knowing to the knowledge feasting table. And here to the right is one of my pieces of art known as, I called it Urban Feast. So again, before I begin, I have to talk about what informs my Debwaywen. So in the Anishinaabe knowledge tradition, we value that knowledge comes from within. And so it's really important that you know who you're learning from. And that's what I did earlier. I began with a traditional teaching or traditional introduction to say who I am. But today we should also know, where people work, what their education is, and because of course that shapes their truth. So I am now an Algonquin Anishinaabe from Pikwakanagan First Nation. I'm from Toronto. I'm currently living in Peterborough. I have a vision disability that's really shaped my existence. I have a PhD in Indigenous Studies. The topic was the Algonquin land claims and self-government process. I have an MA in Canadian Studies and Native Studies. I looked at issues of identity politics. That's a big issue right now. I have an undergraduate degree in cultural anthropology. I also have a diploma in chemical technology, and I worked in the environmental field for 12 years, monitoring Ontario's lakes and rivers for toxic organic pollutants. And as many people know, I've been on a decades-long journey with Gehl versus Canada, but I'm also an artist, a writer, an advocate. So here's some of my art here. So up here on the right, I have a petroform I made in my backyard, and I carved a little turtle. I've done some cattail weaving. So again, it's important that people understand that I am not a lawyer. I was the plaintiff in Gehl versus Canada regarding the issue of unknown and unstated paternity in the Indian Act. Is just a few pictures of me, and there's one at the bottom is me with my grandmother. So I'm going to situate people with where I am. So I'm Lynn Gehl down at the bottom. My Indianness, my Algonquinness came through my father and my grandmother. And my grandmother gets her Algonquinness from both sides, her mother and her father. So that's really important to understand that when I was doing my research, I not only had to research my grandmother's mother's side, but I had to research my grandmother's father's side to his mother, because Angeline is Indigenous, and so is Anne Jane. So again, here I am at the bottom, and I talk a lot about my grandfather. I do know who my grandmother, rather. I talk a lot about who my grandmother is. I do know who my father is. I don't know who his father is. So I don't know who my grandfather is. So before I begin, I think it's important for everybody to understand that in 1985, when they claimed to bring the Indian Act in line with the Charter, they created two forms of Indian status. Well, two main forms, 61A and 61C. That just refers to Section 6 of the Indian Act and subsections. So although they said that they were removing the sex discrimination in the Indian Act to bring it in line with the Charter, in fact, they didn't. And how they caused bigger issues, I guess you could say, is through the 61A, 61C hierarchy. So a 61A is the strongest form of Indian status, whereas the 61C is a weaker form. And when they reinstated the women who were forced out, they only gave them 6-1C. And through that subcategory, what ended up happening was the second generation cutoff rule hit their grandchildren. So their grandchildren wouldn't be entitled to Indian status, but on the other side, the grandchildren of the men would be 6-1As. So you can see how the 6-1A and the 6-1C hierarchy became an issue, or was an issue. And then here there's the issue of unknown and unstated paternity. That's what my court case was about. But the 6-1A, 6-1C hierarchy does intersect with it, so it does get confusing. So essentially, a 6-1 mother, where a father didn't sign the birth certificate, the child would be a 6-2 Indian. But if a 6-2 mother and the father didn't sign the birth certificate, the child would not be entitled to Indian status. So in my situation, I don't know who my father's father was, and they just assumed it was a non-Indian person. And through that assumption, I was denied Indian status. Even though I was born before 1985, the second generation cutoff rule was hitting me.
Dear Madam, I am in receipt of a copy of your letter recently sent to the Indian Affairs Branch, Ottawa, with regard to your status as an Indian. In reply, I wish to inform you that you are not an Indian as defined by the Indian Act. At the time of your marriage to Joseph Gagne, a white man, any rights you had as an Indian of the Golden Lake Band ceased, as seen in Section I-4 of the Indian Act, and you became a white woman. Yours very truly, H.P. Ruddy, Indian Agent.
So this is a letter that the Indian agent sent to my great-grandmother in 1945, and as you heard, she was turned into a white woman. This is her up here, and Annie Jane is my great-grandmother, and this was her husband, Joseph Gagne. You can see he's not a white man, but they considered him to be a white man because his father was white, his mother was indigenous, and then in turn, because he became white, he turned her white, and he literally said, and you became a white woman. So the Indian agent was H.P. Ruddy. So I want to go on and talk about Section 15 of the Charter, because that's what my case was based on. It essentially says that every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. So when they brought in the Charter, and I realized that, well, you know, they're discriminating based on sex and race, and so I think I have a case here. And I think what's important too, it says every individual is equal before and under the law. It doesn't just say before the law, it says under the law. So what's inherent? So this here I have for my timeline, which comes directly from the book. It's 15 slides. I'm not going to read it all. I'm going to smash right through them as an effort to illustrate how ridiculous this process was. So I'm not expecting everybody to get all this, because that's what the book is for. So I'm just going to read a few things. So it was in 1865 when my great-grandmother Angeline Jocko was born, and it was in 1945 when Indian agent H.B. Ruddy sent my great-grandmother the letter that she was now a white woman. So you can see that my court case, Gehl versus Canada, predated me. It was an intergenerational issue. So it was 1985 when they amended the Indian Act, and that's when I started to do my family oral research and my archival research. My grandmother was living up in Temiskaming, and you know, do have a vision disability, wasn't able to read much. It took me 9 years to do the research, and finally we applied. I had some family members that were helping me, and my great-grandmother was registered, and so was my grandmother, but they were registered as 6-1C and 6-2, so that meant my father wasn't entitled, so I had to go back and do further research. And I managed to find some archival documents and have my grandmother upgraded to a 6-1F. But I wasn't sure what they were going to do with my unknown grandfather, and they denied me registration. So they did give my father 6-2 registration, but they denied me. So that's how I ended up in the court process. And here we are in 2001. We filed the statement of claim, and but that first statement of claim was struck. We went to the Court of Appeal, and the Court of Appeal agreed with the lower court that it should be struck because my lawyers were challenging the INAC's practice of determining that my unknown grandfather was a white man, because there was nothing in the Indian Act that said that they could do that. They were just doing it at the level of policy. But the court said we couldn't do that. We had to actually challenge the Indian Act. So we filed another statement of claim shortly after. In 2005, there was a protest on Parliament Hill. I participated in that. In 2006, they decided to switch my court case from an action to an application. And in 2006, Chief Kirby White Duck and I both provided affidavit evidence for the court case. And in 2007, Sharon McIver was challenging the 6-1A, 6-1C hierarchy that I spoke about. And she was successful at the lower court level, but it was appealed, unfortunately, and the appeal court grossly narrowed the McIver decision. September 2007, I was cross-examined. This was just a few days after I submitted the first draft of my doctoral dissertation. On 2009, that's when the Court of Appeal grossly narrowed the McIver decision, thus leaving some of the sex discrimination intact with 6-1A and 6-1C. Although Sharon McIver wasn't addressing the unknown and unstated paternity issue like I was. Some issues were being raised in her court case about it. In 2010, this is 25 years later, after the Indian Act was amended to bring it in line with the charter, there was another protest, March of Moon. That's where I birthed the 6-1A all the way clause, or the concept rather. It's a concept that I created for the purpose of giving the ideology more currency. And in 2010, the Sharon McIver's lawyers submitted their petition to the United Nations regarding the issue of sex discrimination in the Indian Act, because she had exhausted her all possibilities here in Canada. And while she was doing that and moving through the United Nations, Bill C-3 was amended, the Indian Act, again, leaving some of the discrimination intact. No matter what we did, or no matter how many protests we had, we couldn't get Canada to eliminate the sex discrimination. In 2012, INAC finally posted its unknown and unstated, well, its unstated paternity policy online, but it failed to address situations of unknown paternity, such as in cases of rape, for example, when you don't know who the father is. So they were in denial that happens. And then in 2012, my case was ordered dismissed with costs because it was just taking too long. 2012, 2013, I initiate an online petition for the purpose of raising awareness and to disseminate information about my court case. And I also constructed the concept of the Indigenous Famous Five, again, as a way to give the ideology currency, AKA as a counter-hegemonic tool. In 2014, we're heading to the Ontario Superior Court, and there's a real time crunch between the Department of Justice. I think this is a strategy of beating us, I think. I really believe it was. There was some, again, a time crunch and issues of illness in the Department of Justice. And then finally, in October of 2014, my case was heard in Toronto with Honorable Elizabeth M. Stewart presiding. And in 2015, here's the Court of Appeal. We had to go to the Court of Appeal because I lost at this Superior Court level. It was a real pitiful lose. Is that the right word, Nick? A real pitiful loss it was. And there's during in our pathway to the Court of Appeal, we discovered that there's some evidence that the Department of Justice didn't disclose. Anyways, again, I lost in June 2015, even though some of the evidence wasn't adjudicated. And at the same time, there's the Deschanel case coming out in 2015, and they're addressing issues of sex discrimination known as the siblings and the cousins case. At the same time, Sharon McIver's at the United Nations level. And Prime Minister, so they win, just the Deschanels win, but then Stephen Harper, he appealed the decision. And at the same time, we're trying to get that evidence that they didn't disclose to us. So there's a lot going on. And so we finally get the evidence that they didn't disclose to us for our court case. And what's really unfortunate is this evidence would have made a difference in my court case at the Ontario Court, Superior Court level. So we have to submit new evidence at the Court of Appeal level. Here we are in 2016 continued. The Department of Justice wants an extension. Again, it's a time crunch. I think it's a strategy. Okay, let's see what else is going on. So during this time when I'm heading towards the Court of Appeal, Bill S3 is moving through the Senate based on the Deschanel case. And the House of Commons is arguing that they resolved all the sex discrimination. Meanwhile, McIver's at the UN level and I'm at the Court of Appeal level. And so while Bill S3 was moving through Parliament, the Gehl case is heard and it's determined that I win. But I win through administrative law, not through charter law. And I'm only granted 6-2 status, which is a lesser form of status. So that means I'm faced with a new form of, another form of sex discrimination. So although I'm granted 6-2 status, of course, I'm still standing behind Sharon McIver and the 6-1A all the way issue. But the Bill S3 people, as it was moving through the House of Commons and the Senate, they did not want to address the 6-1A all the way issue. Is hard. We rallied hard, we tried hard, but it just did not happen. In 2018, FAFIA, the Feminist Alliance for International Action, introduced the concept of the Indigenous Famous Five, which is essentially after the Indigenous Famous. They introduced the Indigenous Famous Six, which is after what I had created, the Indigenous Famous Five, and they added me to the famous people. In 2019, the McIver decision was heard, and the United Nations said, get rid of it all. They actually relied on the 6-1A all the way concept in their decision. So there was Canada stuck. Right? They were saying that they were eliminating all the sex discrimination, and the United Nations said, no, that's not true, address it all. And then finally in October 25th, 2019, that's when I was upgraded from a 6-2 to a 6-1A. But there's actually a subcategory to it. So this here is a short timeline. I know the long one could be overwhelming. So again, in 1945, my great-grandmother was told she was a white woman. 85, the Indian Act was amended. I applied for status in 94. The first statement of claim was in 2001. It was struck. We filed again in 2002. In 2015, the Ontario Superior Court renders their decision, and I lost. And then we go to the Court of Appeal, and they the judgment is released, and they relied on administrative law versus charter law, and they also made the statement that I was entitled to 6-2 status. So, and then there it is there on October 19th, that's when I was upgraded from a 6-2 to a 6-1A.3. So, whoa, let's go back here. So a lot of people want to know how long it took, and that's a difficult thing to say. From application to the 6-2, it was 23 years. But we have to remember that, you know, it was my great-grandmother who was escorted off the reserve. So if you look at this intergenerationally, it's more like 90 years. So here, some of the things that I did to, I guess, keep it in my consciousness and keep it in the collective consciousness of people. Here I did a talk in 2005. Here's some images from the protest. My famous sign, I felt like a fool, but somebody had to do it. There's my national strategy to raise awareness on unknown and unstated paternity. In the Indian Act, I realized that I needed to keep people informed, have a support system, and I started a petition as well. Here's a protest I was at in 2010, just after I think it was just after I received my PhD. There I am with Sherry McIver, and after this protest, the Indigenous Peoples Solidarity Movement, Ottawa, they had a feast for us, and it was for me it was great because I got to meet Sherry McIver, and I remember her speech. She gave a speech, and she began it with, "I'm an old squaw." Here's some writing I did. I created the Indigenous Famous Five with Mary Tuax Early, Jeanette Laval, Yvonne Bedard, Senator Sandra Lovelace, and Sharon McIver. There's my 6-1A all the way concept. Here we are in the Ontario Superior Court, 2014. Again, I lost. And I lost. One of the arguments the judge ruled was that all applications are treated the same, whether it's a man or a woman. Well, that's a ridiculous statement, because that doesn't mean that there was no sex discrimination. I was still treated differently because my Indian status was coming through my mother line versus my father line. You know, it wasn't just an issue of how applications are treated in the office. Fortunately, there were 3 errors along. We could move forward to the Court of Appeal. Here's the Court of Appeal. And I won. 2016. Here's the picture outside the hotel window of the Court of Appeal. So again, I won, and I put that in quotation marks because I won based on administrative law, not charter law, and I was only granted 6-2 status. We still had to protest, and based on the United Nations decision, eventually I was upgraded to a 6-1A. So here's some expert testimony in the Senate and the House of Commons. Things were moving fast once the decision came out. This was a sad day when, on June 21st, 2017, when the Minister of Status of Women, Miriam Munsef, voted against us regarding removing all the sex discrimination in Bill S3. She stood up and voted against us. It was a sad day. So there's some of my art. Some more of my art. It's my timeline, trying to keep track of it, trying to make sure I embodied the knowledge. It was in my consciousness. I was playing around with things. Of course, this is tied to a plunger. Here's some pictures. This is coming out here in the top left. It's a photograph just coming out from the Senate where I gave Senate testimony. Here I am with Senator Lillian Dick and Sandra Lovelace. in the parliamentary dining hall. Here's the famous six up here with Yvonne Bedard, Jeanette Laval, Sharon McIver, Senator Sandra Lovelace, Senator Eva, Lillian Dick, and there's myself. And here we are at a press conference. And boom, there's Sharon McIver. She made all the difference. She was in court for 24 years addressing the issue of the 618, 61C hierarchy. And then on top of that, she was for 9 years at the United Nations level. So she's quite the powerhouse. There's just another newspaper article about me and the work I was doing. So again, what happened was with Bill S3, Canada wouldn't remove all the sex discrimination, so we had to continue to protest. So here I am outside of Miriam Munsef's office. She happens to be my MP. She's not anymore, she's been voted out. This is in 2019. So this is getting to the end of my slides, and I just want people to know, before the Indian Act was called the Indian Act in 1876, it was called the Gradual Enfranchisement Act, and prior to that, it was called the Gradual Civilization Act. So here we are at the end. Thank you much for listening.
Hi, Lynn.
Hi.
Can you hear me okay?
Yes, I can.
All right. Thank you for the presentation, Lynn. First, I want to say thank you for inviting me to work with you to launch your third book. It's a very important book, and I learned a lot in this book. So, and there's a lot to talk about in this book. So I just wanted to say thank you, and also to start my first question. And I know we only have 10 minutes, so I prepare a few questions about, we'll do whatever we can in this 10 minutes. So my first question is, in this book, I learned a lot, a great deal actually, about Canada's abuse of power through the Indian Act and also through the Department of Justice because of your court case, and also the Indian and Northern Affairs of Canada. And they have different names. They change different names, in the past few years, but they are, they still act in the same way for the purpose of a genocide by disrupting, interfering, and manipulating Indigenous identity. Canada's Indian Act essentializes who is Indian and creates a hierarchy of Indian status, which you talk about in your presentation, by patrilineal and matrilineal lines. So I wanted to begin our conversation with a discussion about Indigenous identity. I was wondering if you could talk about if you could speak about the Anishinaabe way of becoming an Anishinaabe, because I think it's a very important concept to understand in order to grasp fully the destruction of the sex discrimination of the Indian Act to Indigenous peoples, in particular to Indigenous women. Yes.
Yes. So thank you so much for moderating. I did notice that some of my animations weren't working, but it was pretty good.
Yeah, it's good.
Yeah,
great presentation.
I wonder what that's about. So yeah, that's a really good question and a really important question. I would say that that who you are predates that time when you move through the eastern doorway. So your parents, you're listening to your mother talk, you're listening to your father talk, you're listening to people in the community sing and enjoy themselves. It's said that fathers will sing to their babies while their babies are in gestation. So when they're born, they already know who they are as Indigenous people, as Anishinaabe people. I think that's really, really important. That is really, really important, that it predates your journey through the Eastern doorway. It's often said as well that our spirits choose to be born. They choose to be born. They choose our parents. What I think I would like to say about identity is that identity was a social process more than it is a genetic process, more than it is a biological process. You are socialized into being who you are. I think what's really important, being a father, is more of a social process than it is a biological process. And I would say the same thing about being a mother, right? Because biology doesn't make you a mother. It's that love and care that you give. And same as with being a father, right? And I think that based on what I read, is that it was never really that crucial who the father was. It was never really that crucial what your DNA was, what your race was, or what your biology was. In Indigenous people, we adopted children. We adopted a lot of children. So it certainly wasn't something that legislation provided.
Yeah, I really like that. I just remember there's one chapter. It's called "Love to Me." It's the kids. It talk about the indigenous, the Algonquin. I think the indigenous knowledge of mothering. I guess I think it's very beautiful. Like the idea of like taking care of the children. That doesn't matter if the children was born through you, or it's like it's all part of a community. So I really like that chapter. I'm just checking the time. We have like 4 minutes before you do your reading. So I wanted to kind of mention about there's one chapter. You talk about the disenfranchised spirit theory, and then you talk about the story of a Skip Ross, and then you talk about how the process for you helping him to gain his Indian status. And I find that the story is it's so beautiful. It's very touching. And then you talk about even though gaining his Indian status did not make Skip more Indian. I mean, his spirit name is River Main Running. In by gaining his Indian status did not make Skip more Indian, but the affirmation of his identity gave him a sense of purpose. So Skip is able to live a more productive life and take on the responsibility of protecting the Petawawa River where he was born, and the ancient knowledge of the American eel and the lake sturgeon. So I was wondering if you could talk about the link between a healthy indigenous identity production and Pima Disiwi, the good life of indigenous peoples and the wellness of the mothers. So I find the story kind of, this is my takeaway anyway from the Skip story. So I was wondering if we could, talk more about that connection.
So Skip is no longer with us.
Okay, I'm so sorry.
Yes. I just wasn't busy enough. I had to help Skip, right? That was a really hard thing for me to do. And it was interesting. I was really reflecting hard on it because at that time I was already in university and I was really being shaped by medical anthropology. And in my mind, I thought, if I'm going to do this for him, he's going to have to come to the archives with me and bring the quarters, right? I needed him to invest his agency in the process because I knew that if it was going to be medicine for him, it would be more medicine if he was invested in the process. And it was really a special thing that he ended up turning things around. He quit drinking, and it is a contradiction that such an older gentleman, Indian status registration would be so significant to an older person. A lot of people do judge me along the way. I was in my 20s when I first started doing the effort, and a lot of people started to challenge me about having a colonial mindset that, I was colonized Indian, I just needed to be a status Indian. Indian. And I had to really think hard about that because it wasn't just about me.
Mm-hmm.
It wasn't just about me. And, you know, and when do you quit? When you're 5 years into it, or 10 years into it, or 15 years into it? You know, there's a lot of young mothers in the northern communities who need Indian status registration for medical and treaty rights and benefits. So I think that the problem with it is that the state has disrupted our identity productions, right? They've really disrupted it. And, you know, that's what's so wonderful about, you know, getting our spirit names and learning, you know, the language and learning about the culture, because that is really where our identity is. It's not in Indian status registration, but we do have to live with the practicalities of Indian status registration. And so we can't just go around cutting up our cards and suggesting that young mothers cut up their cards when there's nothing to replace it with. So I think that there's probably a lot of very healthy people that have healthy identity productions that are not status Indians, and that's a good thing, because and we're going to need that more and more, because the second generation cutoff rule continues to exist. You know, people who are having children with people who aren't entitled to Indian status, after 2 generations they bump out. But I think that today, hopefully, I don't think it's always the case though, if you have come from a healthy home, your parents root you in the culture, root you in the language, it won't be such a devastation be told you're not an Indian or not Algonquin. So, you know, it was illegal for me to be Algonquin. It was illegal for my father to be Algonquin, and it was illegal for my grandmother to be Algonquin. And it was devastating, not only because we were denied our identity, we were denied a relationship to the land. We weren't entitled to the land we needed to live on. So it wasn't just that they took away Indian status registration, they also said, and by the way, you're not entitled to any land. So, you know, I think one of the reasons why I am quite open and vocal, and I'm proud of who I am as an Algonquin person, is because I think young women and young men need to see, they need role models to look up to. They need to feel proud about who they are, and especially the young ones. So I'm not sure if I answered your question, but I gave you a response.
Yeah, it's great. It's great. I mean, you answered my question. I'm just checking the time. I think it's the time for you to read, to do a short reading. So.
Okay, did you want me to go ahead, Pei Ju?
Yes, please.
Sure. Okay, so I selected chapter 1. Nick helped me decide that because I needed it to be mansplained. So it's called Fighting for Recognition. It's chapter 1. It's going to take me, you know, 5 or 6 minutes to read it. I'm not the best reader because I have a vision disability, so keep that in mind. So in the Algonquin Anishinaabe tradition, Dabajamowin, or personal storytelling, is valued as a legitimate method of gaining and conveying knowledge. Dabajamowin is holistic in that it values knowledge that is more than just what is rational. It is emotional and spiritual too. For me, most days, and especially Remembrance Day, are a bundle of contradiction in that my lived experience is laden with the genocide of colonial Canada, both historically and in a contemporary sense. The Algonquin Anishinaabe are a nation of people who straddle what is now called the Ottawa River watershed. Through processes of colonization, we are now divided into provinces by language, law, and religion. We were denied a treaty during the historic treaty process, and Canada's parliament squats on our land. My great-grandfather, Joseph Gagne, served in the First World War. On September 12, 1910, in Eganville, Ontario, Joseph married Algonquin Anishinaabe Annie Jane Manasse. Joseph and Annie Jane were members of the Golden Lake Reserve, now called Pikwakanagan First Nation, raising their 5 children, Viola, Cecilia, Gordon, Kenneth, and Steve. Viola, their first child, was my kokomas. Through archival research, I gained a copy of Joseph's attestation papers that are dated May 12, 1916. His birthday was recorded as April 7th, 1890, making him 26 years old at the time of his enlistment. He was recorded as 5 feet 7.5 inches tall. He had brown eyes and brown hair and a medium complexion, and was listed as a Roman Catholic. Joseph enlisted in the 207th Battalion and then transferred to the 2nd Battalion. He served in Canada, England, and France. I learned that his port of embarkation out of Canada was Halifax, and he left on my Kokomis Viola's 6th birthday, May 28, 1917. His port of disembarkation was Liverpool, England, and on June 10, 1917, he was demobilized on January 24, 1990, remaining a private for the duration of the war. According to the record, Joseph received the British War Medal and the Victory Medal. Family oral history, though, informs me that he may also have received the Military Medal. I've never seen these medals, and I'm not sure where they ended up. The feelings that the military records and the oral tradition evoke of a dutiful, decorated soldier are real enough for me. After the war ended, Joseph returned to his family and home community, the Golden Lake Indian Reserve. From my family oral history, I've learned that shortly after, in the 1920s or early 30s, the RCMP escorted him out of their community because his indigenous identity was borne by his mother's ancestral line rather than his father's. The indigeneity of his wife, Annie Jane, was irrelevant because women, according to British law, were mere appendages of their fathers and husbands. Apparently, this practice was commonly imposed on Indigenous veterans and their families. When they came home from serving as the British Crown's loyal allies, they lost all their treaty rights as Indigenous people. While the Algonquin Anishinaabe are the traditional Indigenous landholders of the Ottawa River Valley, through colonial practices, policies, and laws, many of us were and remain denied the right to pass on to our families our national identity and our rights as Indigenous people, such as the right to own land and resources, and via this, the right to live Minabamadzawin. Rather, as historians have argued, we were stripped of our national identity, and many were relegated to living on reserved communities where we could prove, until we could prove we met the British criteria of what is meant to be civilized, what it meant to be civilized. The reason for this was that British Canada did not view the Algonquin people as real people, but rather as pre-human beings without legitimate identity, culture, or governance traditions. Consequently, we also lacked a violent holding of the land. In concrete terms, the legacy of these colonial policies and laws also manifests today in the intergenerational transfer of land holdings in the form of what is and what is not willed to their children and grandchildren, or of settler families and Indigenous families. The short story is that many settler families continue to benefit from Indigenous land and the denial of land rights. In this way, settler Canadians, you should know that my great-grandfather went to war for your rights, not mine. When I reflect on this reality, I am saddened that Joseph Gonley fought for a country that took so many away from his families, so much away from his family, from his children, his grandchildren, and great-grandchildren. As Indigenous people of this land, my ancestors deserve the right and the responsibility to care for their children and to provide for them Minabamadzawin. This is my story. Learning and sharing and remembering it should not be this hard, and yet you will see as we continue that my story has been a difficult and ceaseless intergenerational challenge and defeat of the Wendigo that Canada's foundation rests on. Miigwech.
Thank you so much for the reading, Lynn. I agree with Nick. It's a good chapter to read. It gives us a clear picture of where this is coming from. And I think it's very devastating to read, you know, your great-grandfather went to war for settlers' rights, for your rights. I mean, settlers' rights, but not yours. Yeah. I think it's very, when I read it, it's very devastating to know that, you know. Yeah. So we're going to open up for Q&A with the audience. So if you have any questions, please put your question in the chat. And I also, before we go into the questions, I want to remind you that you can purchase a copy of Lynn's book, Gehl versus Canada, at Octopus Books. So I believe the link to purchase the book is shared in the chat as well. So please click link and then purchase the book. It's a very good book. I really recommend it. So the first question here is, what advice do you have for others who may be feeling discouraged or disheartened by processes and bureaucracy when challenging unjust or inequitable rulings? What kept you going?
Oh, that's a question from the audience.
Yes.
Well, I think it's just dogged determination. I just wanted it to end. I don't know. I mean, it's the same thing applies with my education. Took me 13 years to get my PhD. I don't walk away very much, but I have walked away. I walked away. I was doing vision training, and I walked away from vision training. I just needed to see it end. I just needed to see it end, and I think that was really, really hard. Was that it just wouldn't end, and the Department of Justice had so deep pockets, right, to tie up my agency. I don't know. Try and find joy somewhere. I worked at a farm for 3 years or something, and I didn't have to use my cognition very much. I was just cleaning it up and decommissioning it, and that was nice to not have to use my cognition. I don't know how. I think it's just dogged determination. You know, I hear people used to say to me, I was like a dog with a bone. I can't give any great advice. You know, stay away from drugs, stay away from alcohol, try to get outside and go for a walk. Don't let yourself get too obese because you're going to be sitting in front of a computer a lot. Don't take things personally. Because it was bigger than me. You'll see in the book, a lot of people did some bizarre things to me, and I decided I wasn't going to take it personally. I think what drove me was I was determined to serve Indigenous women and children.
Yeah, thank you. Yeah, thank you for your persistence. I think that's one person from the audience say thank you, Lynn, for your persistence throughout this process, which is very remarkable. Included both legal and your legal case and your activism. So, and the next question is, are there any other issues of sex discrimination that still is in existence in the Indian Act that Gehl versus Canada couldn't address? Do you see any way forward for these challenges?
Well, there certainly is issues with the sex discrimination in the Indian Act because Canada's court decisions takes very, very, very narrow remedies. They find really narrow remedies for these situations, and they did that in Cher McIver's case. They did it in Lynn Gehl's case, and we all know that they're doing it with the situation with Cindy Blackstock. The court takes very, very narrow approaches. Instead of broadly serving Indigenous children, they narrow it, and because I guess it's related to money. So in my situation, it was on about unknown and unstated paternity. I don't know who my grandfather is, but the Court of Appeal determined that there was enough circumstantial evidence to assume he was an Indian. So that meant that the issue of unknown and unstated paternity continues to remain unresolved. The core issue of Gehl versus Canada remains unresolved. There are situations of rape where you don't know who the father is. There's valid and legitimate reasons why a father's name is not on a birth certificate. Sometimes the father won't sign. They won't have anything to do with the child because the child was born from a young mother or young girl. 14, 15-year-old girls, men won't sign those birth certificates. There's issues like that. So it continues to remain unresolved. I think what is clear to me is that Canada is determined to get rid of Indians and target children in the process.
Mm-hmm.
It's really quite sad.
Mm-hmm. Yeah. Sorry, I get lost. Can you talk about the next question is, can you talk about the invention of the 6-1 and 6-2 hierarchy, where women and their descendants continue to be discriminated against?
So there's two hierarchies to understand. There's the 6-1A and 6-1C hierarchy. Mm-hmm. That was pretty much resolved through the MacGyver decision. And what that was about was we wanted to have all the children born before 1985 as 6-1A, the same as men and their descendants. Everyone who was an Indian in 1985 was granted 6-1A status, everyone who was an Indian. But the women who were reinstated were granted 6-1C, and as a result, the second generation cutoff rule hit them earlier before 1985. So for example, I was born in 62, and so was my father, and we were hit by the second generation cutoff rule. So they were taking the second generation cutoff rule and applying it retroactively. Now, a lot of people don't understand the second generation cutoff rule, but you have to put your cognition into that. Put your cognition into it and think about this for a minute. If you go to Britain, England, your child will be entitled to remain a Canadian citizen, but your grandchild will not be. It's a second generation cutoff rule. So it's a bump and you're out. But we're talking about Indigenous people on our own land. So I just use that as an example so people can establish a relationship of what is second generation cutoff rule. So in 1985, they reinstated the women and their children born before 1985 as 6-1As, the same as the men and their children. The second generation cutoff rule continues to exist. We did not eliminate the second generation cutoff rule. What we did was we said, if you're going to use the second generation cutoff rule, you have to apply it equally. So now whether you're a man or whether you're a woman, and you have children with a non-status person, the child would be a 6-2. And then if that happens again, then the child will not be entitled, whether you're a man or a woman or a grandmother or a grandfather. So that sex discrimination has been addressed. And the second generation cutoff rule continues to exist. It continues to exist for both men and for women in a more or less equal way. And that is how Canada is eliminating Indians, right? That's how Canada is doing it, through the second generation cutoff rule. In 1985, when they amended the Indian Act, prior to that, Indian status pretty much went down the man line. In 1985, that's when they invented the second generation cutoff rule. And I'm sure a lot of the men didn't want the Indian Act tinkered with because of that very issue. So Canada was very clever. They took the amendment, they amended the Indian Act in 1985 to bring it in line with the Charter. They created new forms of sex discrimination, and they invented the second generation cutoff rule, the goal being to eliminate Indians. So they use the legislative change as an opportunity to make things worse. And that's really important. Like, people should never assume that legislative change is intended to make things better. Never trust that.
Mm-hmm. Yeah, that's true. Canada is very manipulative, I must say. All right, the next question. Can you talk about matrilineal discrimination and what is it?
Yeah, so this again, you have to put your cognition into this. So when I was going through the court process, the Department of Justice was making arguments that it wasn't my discrimination, it was my father's discrimination and my grandmother's discrimination. They wouldn't accept the fact that I was being discriminated against because of my grandmother. And I think it was in Sharon McGarver's decision, they called it, it's not sex discrimination as it is stated in Section 15 of the Charter. They said, oh no, that's matrilineal discrimination. Lynn, you're not facing sex discrimination, and Sharon, you're not facing sex discrimination. What you are dealing with is matrilineal discrimination, and that is not part of Section 15 of the Charter. So it's like they invented this term as a way to make a legal argument that they weren't violating the Charter. So it's pitiful, really, is what it is.
Yeah, it is. All right, it's an audience say, thank you so much for your presentation, responses, and reading. Do you make a connection between gender discrimination and disability discrimination against Indigenous peoples, specifically Indigenous women?
Well, I think that's a hard question. I think certainly women have to deal with sexism, and it's harder for them to move through structures of society. And as a result, they're going to have a higher and an increased rate of disabilities. I mean, it's known that Indigenous people do have a higher rate of disabilities, and women more so. So is there a link between them? Sure, there's a link. There's a link between genocide, racism, sex discrimination, and disability, certainly. Yes, and that's not because our bodies are inferior. It's because, you know, we have poor housing and poor water and things like that. So I think even in the general population, women have a higher rate of disability just because of sexism, right?
Yeah, and like it's all, I mean, correct me if I'm wrong, it's all process of colonization, right? You know, like purposefully providing or making the environment for Indigenous people, poor environment for Indigenous people, so the disability rate is higher in Indigenous communities than non-Indigenous communities.
Yes, I would agree. And you know what's really important about this issue is treaty rights, well, if you call them treaty rights, but Indian status registration provides medicine coverage, right? So mothers and their children get their medicines, their treaty rights, their medicine is paid for. And so, you know, you have a higher rate of disability. And so that's why it's even more important for Canada to get these women and their children Indian status registration, right? They're lagging, they're slow at giving us our Indian status. I mean, a niece of mine, she just received Indian status registration a couple weeks ago, and I'm sure she applied well over a year and a half ago. It's nothing like me, but yeah, the administrative process is really lagging. INAC is not moving quickly enough, yet we have these mothers with disabilities who need, and their children with disabilities who need their treaty rights and their medicines.
The next question, it's a big question. The question is, do you think the Indian Act should be amended or abolished?
Well, I think that Canada has to honor reconciliation and nation to nation. Canada has to honor the fact that our territories are our territories, the reserves are not our territories, and we have a right to the resources from those territories so that we can live well. You know, people who are running around ranting about abolishing the Indian Act, they should really go and think about what that means really hard, right? Like, we are not sitting with our Indian status cards and worshiping. We understand the limitations of them. We understand that they're colonial. We understand that we were in the context of genocide. The second generation cutoff rule is that, but we're in a really difficult situation. So I would rephrase the question of, let's shift the focus on making Canada honor our larger territories and the resources from those territories. Instead of sitting here having a silly argument about abolishing the Indian Act, right? What are you going to replace it with? Of course we should get rid of the Indian Act, but let's replace it with something that is useful, that is something that will protect mothers and children. We just don't want to run around, hairy canary and abolish the Indian Act and then leave these women and children in a worse off situation, right?
Yeah, I agree. All right. So the next person said, "Thank you, Lynn. In long, costly but needed fight against the Canadian government for the rights and struggle for 6A all the way. Do you think this genocide against Indigenous peoples will ever stop?"
So Canada is certainly, this is how I say it, Canada is committing genocide in two main ways: the second generation cutoff rule, and through the land claim and self-government process. They call it the modern treaty process, but it's a lie. It's a land claim and self-government process that forces us to extinguish our land rights. So they're committing genocide through those two main ways: second generation cutoff rule and the land claim and self-government process, and denying us our land and resources. Do I think Canada will ever end this process of genocide? Not as long as the Prime Minister of Canada is in the Parliament lying about it. When I think about the Algonquins, for example, and the genocide that we're facing, they divided us into Ontario Algonquins and Quebec Algonquins. They've made a real mess of the Algonquins. I think the British really hate and loathe the Algonquins for what they're doing to us. I think that the Canada has deep pockets to manipulate the agency of many people, to make many people complicit in the genocide. Lawyers, parliamentarians, and so do I think it'll ever end? I'm at the point where I'm starting to think it's an industry. Genocide is Canada's industry against Indigenous people. So a lot of people will think that it's not a genocide because they're not lining us up and shooting us. Well, the denying us our culture and our resources is genocide. Right? Genocide is more broadly defined than lining us up and shooting us.
Yeah, I'm just thinking, just listening what you were saying. I'm thinking, like as settlers, I think we need to demand Canada to stop the genocide, right? Like, I mean, it's increasingly, I hope, there's a lot of talk about climate crisis, climate change. I think if we want to mitigate, I guess, climate crisis, we need to demand Canada to stop genocide, because these two are all connected. Does it make sense?
Yes, yeah. The Indigenous paradigm is phenomenally sophisticated. It sits closer to natural law versus human-made law, and so there's a tight relationship between the genocide of Indigenous people, the genocide of our knowledge system, and climate change. Yes, and what's really sad is that all Canadians need clean land, air, and water, not just Indigenous people. And it's our knowledge system. It's our knowledge system that understands and values the land and the water is sacred. If you understand the water and land is sacred, you're not going to destroy it, right? So I think one of the barriers, though, I think, is a lot of the Canadian citizenry don't really understand what genocide is, and they don't really understand the role of cultural knowledge and Indigenous knowledge has. You know, they don't really quite understand the difference between a humanistic paradigm and the naturalistic paradigm.
Mm-hmm.
I think they set up false dichotomies, and they're too busy. They're working, you know, working 40 hours a week. And so I think the Canadian citizenry needs to start thinking on their own. They need to do their own reading. They need to, the locus of control is internal. They have to do the work and the thinking. It has to go on in their cognition. And, you know, once they think about it, they'll get it, you know.
Yeah, I hope so.
Yeah.
All right. The next question is, the Department of Justice failed to disclose evidence in Gehl versus Canada. Can you please tell us more about that? Why do so many of these court cases with Indigenous peoples take decades to come to completion?
Well, they take decades to come to completion because the Department of Justice is the biggest law firm in Canada. They have deep, deep pockets, and the coming from the resources of Indigenous land, right? They're paid. That's how they do it. They just burn you out. They hope you die. It's not funny, but I'm convinced that's what they were trying to do, was kill me. I think, yes, they did fail. They did fail to disclose evidence. And that's a really sad thing, that the legal system and legal positivism, it's shaped by power. And so much so that the Department of Justice lawyers just failed to disclose one really important policy that was talked about, the issue of unknown and unstated paternity. So in 1985, prior to that, this is so interesting. Prior to 1985, there was a provision in the Indian Act that protected children of unknown and unstated paternity. So it was I would say, a really lovely clause to protect children. When they amended the Indian Act in 1985, they took it out and became silent on the issue. And so what they were doing is, at the legislative level, they became silent on the issue of unknown and unstated paternity. And then at the departmental policy level, they just started to assume the man was a white man. So they just shifted their discriminatory, they hid it. They hid it. So the Indian Act was amended to create a silence on the issue. And you know, I was aware that prior to 1985, there was this provision that would protect people like my father and myself. But they didn't honor that, you know, even though my father was born in 1935 and I was born in 1962, they didn't honor that old clause in the Indian Act. And then as we were moving through the court system, you know, the MacGyver case was moving through the court system, and so was the Deschenaux case moving through the court system. And the MacGyver case had issues of unknown and unstated paternity in it. And after her court decision in 2000, I think it was around 2010, 2012, they had this internal policy that said, oh, we don't have the right to deny these children. It's essentially what it was, a really small policy that said, we don't have a right to deny these children, because prior to 1985, they granted the children Indian status registration. But if there was a protest made and it was a successful protest, INAC could deny the child. But they also removed that little clause too. They removed the clause that said that they had the right to deny children. And so in 2010, when they made these post-MacGyver policies, they didn't disclose it to my lawyers. And so by the time, they should have disclosed it, it needed to be adjudicated. So then when we went to the Ontario Superior Court, the judge didn't have that evidence in front of her. And we found out because, you know, the lawyers started to communicate with one another, you know, the MacGyver lawyers and the Deschenaux lawyers and the Gehl lawyers. And eventually we had to pretty much pull it out of the Department of Justice. But by that time we were already heading toward the Court of Appeal. And the Court of Appeal didn't want to address the issue that it was a charter issue. that's when they said, oh, this is administrative. We could just resolve this through an administrative law. So the Department of Justice got away with that. They got away with the fact that they failed to disclose the evidence when I was at the court, at the Interior Superior Court. And that was just ignorance. That was just complete ignorance and power. That's corruption. That was a human being, a couple of human beings, several human beings that allowed that to happen. And I should also say that the Department of Justice lawyers were all women. So it's really quite pitiful that women were doing that to women. So that's the long story about the fact that the Department of Justice, if they don't want to disclose evidence, they just don't disclose it. They have that power.
Mm-hmm.
Or they have that corruption of power.
Mm-hmm. Abuse of power. Yeah.
And you know, if somebody else told me that, I wouldn't believe it. I'd have a hard time believing that because it sounds like an outrageous story.
Mm-hmm. Yeah. But like from your book, it was really shocking to learn that as well. Like, you know, like how they manipulate the process, and the thing is, as you say, you know, they are the largest law firm in Canada. They have lots of money, and on the other side, you are the unpaid client of the Aboriginal legal services in Toronto. So it's just like unbelievable, you know.
Yeah, can you imagine how I felt? Can you imagine how I felt that the Department of Justice failed to disclose? They argued that it wasn't relevant to the case, and it wasn't their decision to make that decision. The judge, the evidence had to be adjudicated. And you know, I think Pei Ju, the Gehl versus Canada, it really is a case study in understanding power.
Mm-hmm. Yeah, that's right. Are you ready for another question? Yes. Okay. So we'll have two more questions before we wrap up. So the question, one of the question is, what was the official reasoning behind splitting status between 61A and 61C?
Oh, can you say that again, please, Pei Ju?
Okay. What was the official reasoning behind splitting status between 61A and 61C?
Well, you can be sure Canada blamed the Indians. You know, you can be sure that that's what they did. I've heard stories that they were trying to navigate a balance between what the women wanted and what the First Nations wanted, right? But you know, there's no excuse, right? A human right is a human right. It's not something that's negotiated, and it's not something that, oh well, we had to balance it out. It was, I believe, many things, a delay tactic. You know, look what happened. Here oh my gosh, in 1985, that's when the Indian Act was amended. It took us another, what? How long? 25 years or 35 years or whatever, 15 plus 20, another 35 years to finally say, okay, give us 61A out of the way. It's a strategy of power to drain the agency of the people, to destroy the women, to destroy the nations, to, I mean, we're all looking for a reason. We're looking for a reason, but it's right in front of you. It's called genocide.
Yeah.
Right? It's called genocide. Like, we're not lying. Like, you know, we're not lying about this. It's genocide. Why are you looking for a reason?
Yeah. Right. So the last question, doesn't the name claims process and the second generation cutoff go against the UN drape? The United Nations Declaration of Rights of Indigenous Peoples. Why did Canada sign on and then continue their genocidal policies? This is the last question.
Yeah, so certainly the second generation cutoff rule, and certainly the land claim process is contrary to UNDRIP. Certainly it is. You know, we have a right not to be assimilated, and we have a right to our land and resources. That's pretty clear in UNDRIP. Why did Canada legislate a domestic version of it? I don't know. I don't know about that. I think it's just, to me personally, who speaks not being a lawyer, I think it's just a manipulation of the Canadian citizenry and their collective consciousness. It's, you know, Section 35 of the Constitution didn't do anything for us. When they brought in the Charter of Rights and Freedom, it didn't do anything for us. The Charter of Rights and Freedom is failing Indigenous women. We know that. You know, the land claim and self-government policy was amended 2 times, and it was a joke. You know, it just shifted from blanket extinguishment to the extinguishment of your land and resources. Why is it happening? Well, I think it's because a lot of Canadians aren't standing behind Indigenous intellectuals and listening to us. I think that a lot of Canadian citizens, they want to feel lovely and happy about Canada. I mean, that's why Canada, you know, they're very emotional and love Canada. So, you know, I come along and other people come along and they say it's a genocide, and that all these things like Section 35 and like amending the land claim policies and bringing in the charter, it's never done anything for me. I have no hope in this domestic version of UNDRIP, none whatsoever. And I do know that, you know, Marie Sinclair likes it, and so does Pam Palmater like it, but that's good for them, but it's not realized at the level of practice. And just to give you an example, the Algonquin of the Ottawa River Valley, we exist both in Ontario and in Quebec, and we were denied a treaty process during the historic treaty process because the British just hate us like no other. We have a particular kind of genocide imposed on us because Parliament Hill is on our land, the Supreme Court of Canada is on our land, the Governor General's home is on our land, it's all Algonquin land, and they've divided us by provinces, by language, by religion, by law. So we have a particular kind of genocide imposed on us, a worse kind, I think. And I think that just to give you a really good example of the nonsense of UNDRIP, a domestic version of it, right now, the Algonquins of Ontario have been offered 1.7% of our territory and an $800 million buyout. They haven't adjusted that. They haven't adjusted that. Now that they have this domestic version of UNDRIP, they're not going to the Algonquin land claim table and saying, oh, we have to share this land and resources with you. We realize we made a mistake. No, they're not doing that at all. So it's right there in the heart of Canada. They are committing genocide against the Algonquin people. They're pitting the Ontario Algonquins against the Quebec Algonquins, and they're not giving us our land, and they're not giving us our resources. So Canadian citizens need to stop externalizing their responsibility in serving Indigenous people and stop saying things like, oh, the UNDRIP's here now, everything's better, right? Oh, Charter's here now, everything's better, right? So when Justin Trudeau came in power, and he was talking about nation to nation and reconciliation, a lot of settler peoples were so happy and so joyful. And what happened was, when I was looking at their happiness and their joy, it was making me ill, because I know that they were projecting, they were hopeful thinking, they weren't listening to me, they weren't looking at my face, you know, and saying, wait a minute, Lynn, what do you know about this? They weren't asking me, did I feel hopeful about it? You know, and I did my PhD on the Algonquin land claim process, so I would have a valid thought on that. I would have valid knowledge on that, not just an opinion. So that's the long story about how UNDRIP doesn't give me any hope, and if it gives you hope, you might want to keep it to yourself.
All right. Thank you, Lynn, for your answers. I think we really need to look under the surface, you know, in terms of what Canada is doing, because Canada is very canning very, very smart in a way. So now it's 8:28. So we need to wrap up for the book launch, for your book launch. So I was wondering if you have a final remark you want to share with the audience, and then and anything you want to say to say goodbye to the audience before we close for tonight.
I just want to say thank you so much, Pei Ju, for moderating, and Nicole, you're like a director. You've been like a director. I think it's amazing how Zoom and PowerPoint and YouTube have come together to do these kinds of things. And I'm so grateful for this opportunity. I'm really grateful to the University of Regina Press, to Karen Clark, for example. She's been so patient with me and kind. I can't say enough good things about the University of Regina Press. I'm so grateful for them, really, really grateful, because it's really hard to get subjugated knowledge published, especially anti-colonial, counter-hegemonic knowledge, knowledge that relies on emotions and subjectivity. Just grateful to Greg at Octopus Books, and really for everyone listening. And of course, Nick, Nick is here. So everyone listening, I'm really grateful. And I hope that people buy the book and understand that it's a different kind of book. It's more like a reader. And I believe it's a really good case study in understanding Canada's corruption of power.
Mm-hmm. Yeah.
Well, I don't want to jump in here, but and cut anyone off, but I wanted to express my thanks as well, both to you, Pei Ju, for hosting and moderating tonight's event, and Lynn, thank you so very much for continuing to share your story and for your inner strength. I mean, you're a truly remarkable, strong person. Thank you. And to our audience today, thank you for joining us. Of course, do not forget that you can purchase a copy of Gehl versus Canada online at octopusbooks.com. Yes, Lynn's got hers there too. Thank you very much, everyone. And I wish you the best. Enjoy the rest of your evening. Bye.
Bye. Thank you so much.